Good morning, all. Thank you for attending. We'll give folks just a few more minutes to join before we go over some of the in-system features, and diving into things. Hello, everyone, and thanks again for joining us today. So Kasey will be starting the presentation shortly, but while we wait, I'll quickly go over some of the control panel features that we'll be using. So on the left-hand side of the panel is our microphone icon, and you can use this to mute and unmute yourself throughout the presentation. However, please note that all attendees will be muted until the question period at the end. During the question period, you can use the raise your hand icon to be unmuted for any verbal questions that you might have. There will also be a couple of polls to participate in throughout the presentation. If you are having any difficulties answering these, please ensure the window icon, which is directly below the microphone icon, is turned on. You may also use the chat box or comment box to ask any questions at any time throughout the presentation. Thanks again. We'll begin shortly.
Good morning, everybody. Welcome to our webinar on the Fisheries Act. Just want to do a quick audio check. Leah, can you hear me?
I can, yep.
Perfect. Thank you everybody for joining. My name's Kasey Clipperton. I'm a senior fisheries biologist with Golder Associates. I've been with Golder for almost 20 years now, and I've been doing fisheries work in Alberta, northern Canada, British Columbia, and the United States for over 20 years. So our presentation today is to give, I guess, our perspective on what we've seen in the changes to the Fisheries Act that came into force late August 2019. And again, it's more of an operational view of how the different changes have been implemented in reviewing projects, and to provide our perspective on the different types of projects that you may be involved with, and what regulatory path that they should follow.
Sorry to interrupt you, Kasey, but it looks like you're having a little bit audio issues.
Sorry about that. Is that better?
It is, yep.
Okay. As I was saying, we typically have done these types of presentations in a face-to-face setting. With the current situation of not being able to gather in groups, we're testing out a webinar, so there may be some technical challenges along the way, but I think one of the benefits of this approach is that we may be able to get a much larger audience that has the ability to participate. And so we'll go along. I'll have my video on just for the start, and then I'll just show the presentation. But certainly, if there's anyone's having any issues, raise your hand, and Leah will be tracking that and try to flag the issues for me. The overview of the presentation that we have today. First of all, I'll go over some of the changes. So this change that's happened to the Fisheries Act isn't the first one that's happened in the last decade, and so it's worthwhile going over the history and what we've learned with the previous changes to the Fisheries Act and how they've been implemented. At the time the changes to the Fisheries Act were put out, we had identified what we thought were 5 of the key changes that would change how projects were reviewed right from the start. So we'll look at what we thought they were then, and how they've been applied under current situations. And then after the overview of the major changes, I'll spend a bit of time kind of going through the process of determining what part of the review cycle your different projects might fit in. Whether it can be completely screened out right from the start, follow some of the codes of practices, requests for reviews, or going to a Fisheries Act authorization. My little footnote at the bottom there is, again, I'm a fish biologist, I'm not a lawyer, so this isn't to be perceived as legal advice regarding the Fisheries Act. Again, it's an operational view based on our own experience and working with TFO on how we see the changes to the Fisheries Act playing out. Since we're not face to face, and it's we don't have the chance to really introduce ourselves across the group, we'll start with a little poll just to get a sense of where everybody's from. So first part is just identifying what industry you work in. So if you can start entering on the poll. I know we've had a couple of technical challenges with people not being able to respond to poll questions. I understand if you are having challenges with that, if you click the little window icon in your control panel, that may resolve the issue. So we'll just give everybody a chance here. Perfect. So again, not surprising, we've got a good distribution across the major sectors, and again, I think that's an important point in that the Fisheries Act does apply to all sectors. It doesn't matter what type of work you do. If you are working in or near water, the Fisheries Act does apply to you. So let's go to back to the presentation, Leah, and I'm going to stop sharing my video. I'll jump back on towards the end again, but again, if anyone's having challenges, feel free to type in the chat feature. We will save questions until the end, just for flow. So, but if you do have a question on any of the slides as we go, feel free to type it in, and we'll get to it at the end of the presentation. So from the most recent policy statement from DFO, just highlighting again that the Fisheries Act is one of Canada's oldest pieces of environmental legislation, and it is a very strong piece of legislation. It's vital to the health of our environment and the country's economic prosperity. And even though it is a very old piece of legislation, it's been a bit turbulent in recent years. So leading up to Bill C-68, which was tabled in 2008, there was certainly a period of stability pre-2012 where the Fisheries Act remained unchanged for decades. There were some habitat protection measures that were introduced in the late 1970s. And with that, there's a long history of case law for projects and violations that have happened under the Fisheries Act to define the prohibitions under the Fisheries Act. And the main prohibition at that time was the harmful alteration, disruption, or destruction, or what has always been referenced as a HAD of fish habitat. And there was also a prohibition against the killing of fish by means other than fishing. For a long time, many people may be familiar with the no net loss policy that was in place since the mid 1980s. And then, although not policy, what came to be practice in reality was if you did require a Fisheries Act authorization and what was termed at the time habitat compensation, it was typically built at a 2-to-1 compensation ratio. And again, it was never written down as such, but it did become the norm. So the first big change to the Act happened in 2012, where serious harm to fish replaced the HAD prohibition and the death of fish prohibition, and it was replaced by the single prohibition against the serious harm to fish. There was a focus on commercial, recreation, and Aboriginal fisheries, or CRA fisheries. There was a shift from habitat protection to fish productivity of these CRA species, and this was one of the main criticisms by a number of folks around the lost habitat protection provisions of the Act. And serious harm, the definition included a time component, and that it was permanent alterations or losses to habitat. So the potential for temporary alterations not being covered under the Act was another concern from some groups. At the time, not that it had any meaningful change, but the terms offsetting and equivalency were brought into the policy to effectively replace compensation and no net loss. And then under the new Act, or Bill C-68 was proposed to restore what were deemed as the lost habitat provisions of the Act. This Bill C-68 came into force on August 28th, 2019. So I think just before we jump into the next slide on the changes, I think we've got another poll question just to see the experience of the folks on the phone. So we've had these changes to the Act, and getting the history and perspective and experience of different areas I think is useful. So check all that apply. You can hit more than one. So if folks have had experience working with the operational statements that were in place prior to 2012, working through self-assessments under the last version of the Act from 2012 to 2019, dealing with requests for reviews, and that was a formal process that actually was introduced in 2012. The DFO codes of practice, which are the current tool in place, or a Fisheries Act authorization. So looks like we've got a good response. If you want to put up the poll. So again, a good spread of experience with the different tools that that are out there, and I think we'll draw back on some of these tools as I go through the presentation to give some perspective of how the current Act we think will be viewed. So there were a lot of changes identified in Bill C-68. Here's a list of the primary ones, and again, I guess another caveat on this talk: the Fisheries Act does apply to both marine and inland fisheries. My talk today is focusing on the inland and freshwater side of things. There is a number of changes that were focused on the marine side of the Act that I won't be getting into. But obviously the big changes that affect a lot of the work that we would be involved with are the restoration of the lost habitat protection provisions, or the HAD, protection for all fish species, not just CRA species. There's a new permitting framework outline that identified the ability to have designated projects and developing codes of practice. There's a strengthening of the role of Indigenous peoples in project reviews. There's consideration of cumulative effects and several other new factors. Focus on restoration, the ability to amend, suspend, and cancel authorizations, which is an administrative adjustment that may be useful to some. There's an online registry of project approvals that's actually up and running and online, although the information is fairly limited at this stage. Proponent-led habitat banking and the ability for DFO to establish ecologically significant areas. So a lot of changes to the Act, and when it came out, we certainly looked at those changes and provided some information of the top 5 changes that we thought might impact the types of projects we work with on a day-to-day basis. For those on your control panel, I think there's a handouts label there that you can click, and you can download this this little graphic if you'd like. So we looked at the 5 areas that we thought would result in some changes on how we did business and assess projects on a day-to-day basis, and we'll go through each of those 5 right now. So the first one, and the big one and obvious, was the restoration of the lost habitat protections. And this was the repealing the serious harm to fish and replacing it again with the prohibition of the death of fish by means other than fishing, and the harmful alteration, disruption, and destruction of fish habitat. A couple things on the death of fish. That's always been in place. So there was a prohibition against killing of fish prior to 2012. The death of fish was part of the definition of serious harm up until the change. So it's always been a component of the Fisheries Act and prohibitions in the Fisheries Act. Another big change is the removal of the permanency and the time element of your activity, and that is certainly one that could influence smaller scale projects. In that consideration under the Act couldn't be put aside by the duration of the activity, where serious harm was focusing in on the permanent alteration or permanent destruction of habitat. And I put in quotes the lost habitat protections. I think certainly for larger scale projects, I think the serious harm prohibition still resulted in a high level of habitat protection, and projects were viewed in a very similar manner as they were previously, and as I believe they will be continued in the future. But possibly for smaller scale projects, the serious harm provision did screen out a number of smaller projects that maybe weren't brought forward under the Fisheries Act. The other big change is the protection for all species, so the removal of a reference to CRA species, and to protect the species and all of their habitats. The definition of fish habitat was modified a little bit to clarify that it includes water frequented by fish, but it also includes other areas on which fish depend directly or indirectly in order to carry out their life processes. Again, with this change, I would say the biggest shift probably would be once again on smaller scale projects, where larger scale projects, the consideration of all species still was typically happening. But certainly for smaller scale projects, if you were in an area that that didn't have a CRA species present, and it was certainly a temporary nature, that may have been a information that would have screened out a project from needing consideration under the Fisheries Act. A third big change that's been identified is some direct referencing and obligations for DFO to have Indigenous involvement in the process. There's always been the duty to consult for the federal government, but Bill C-68 certainly strengthens the obligation for project proponents as well as DFO to partner and collaborate with Indigenous groups and local communities in not only the review process for the project, but also supporting and encouraging involvement in development of offsetting plans. And there's a real focus on proponents to engage early in the process and get their feedback. There's also a requirement for DFO and the minister to consider Indigenous knowledge when it's provided to them in reviewing projects and issuing authorization. So again, that may be something that the proponent is involved with, or it's something that is between the Indigenous groups and DFO and the federal government directly in the provision of Indigenous knowledge. And if it is provided, that the minister must consider that when making their decision. The fourth area that we thought would result in some immediate changes to how projects were reviewed was the ability to develop standards and codes of practice. And the idea with the codes of practice in particular would be that it would be a detailed description on how a project could avoid the death of fish and avoid causing a HAD as defined under the Fisheries Act. These would come in the form of a published document, and it would specify procedures and practices for specific types of work. And I think the one flag here for those that are working in Alberta, that there is some potential confusion that the Water Act also has codes of practice. So I think that'll be a careful point to carry forward as you're having discussions with your teams when you reference codes of practice. We're now dealing with DFO, Fisheries Act codes of practice, and Water Act codes of practice. And while they may have overlap, they are different and they may cover different activities. The codes of practice we thought would essentially replace the self-assessment process that was in place under the 2012 to 2019 version of the Act. Talking to DFO, there was certainly concern that there was a lack of consistency on how self-assessments were being applied, not only by proponents and professionals outside of DFO, but also there was inconsistency on how DFO interpreted it, and you would often get different advice on whether a project could be self-assessed or if it required a review. I think this was one of, certainly has been identified by DFO folks I've talked to as a concern with the last version of the Act, that there may have been projects that they did want some input on that were being self-assessed and they weren't seeing. Up front, we thought that these codes of practice would look similar to the old operational statements. Possibly the biggest change, though, the old operational statements, for those that remember, were regionally developed. So there were different operational statements for BC versus Alberta to Ontario to the Maritimes, and the current iteration of this would have a nationally consistent codes of practice. Unfortunately, there's only 2 in place right now for end of pipe screens for water intakes and for maintenance dredging. There are more in the queue. I think there was an expectation that beaver dam removal and culvert maintenance would potentially have been out by now, but I think the COVID-19 situation has slowed the consultation process to get those moving forward. And I do know in talking to DFO that there are a number of other codes of practice in draft floating around, and hopefully will be coming soon. One of which is operating and doing work in the dry, which would include where you can isolate your work site. The last area that we identified as a major change were the factors to be considered, and this is actually a change over time. So prior to 2012, there weren't any specific factors to be considered when the minister's reviewing a project application. In 2012, the factors in black on your screen were brought forward with the change to the Fisheries Act, and in 2019, the original 4 factors have been carried forward, and 4 new factors were brought forward. And these are items that the minister must consider, and so these are things that can't be ignored when you're planning your project and collecting information. One of the big ones here is cumulative effects and understanding exactly how that will be evaluated. This is a requirement for DFO, so DFO must consider the cumulative effects of a project prior to issuing their decision. But at the same time, as with many things, there may be a lot that a proponent can do to provide information to help DFO make their decision. And the more information and detail that can be provided can certainly help speed up the review process. Talking to DFO, they are in the process. They've had some internal discussion and training to make sure that cumulative effects are viewed consistently across the nation, and it's not. We shouldn't have variability from individual, and they are currently working on some tools to help them with this determination. But exactly how cumulative effects will factor in and play into their decision making is still unknown, and this is still a work in progress. So those were the five big changes that we thought would come into play. I think they still are the changes that will affect projects in the immediate term, although some, like codes of practice, aren't quite as far along as we thought they would be at this stage. The next part of the presentation, I'll try to just walk through the process of evaluating a project and any work near water. And really, DFO likes to follow along a hierarchy of avoid, mitigate, and then offset, and that's what this graphic shows. That when you're planning a project, the first step is to do everything you can to avoid the impacts. If they can't be avoided, do everything that's possible to mitigate those impacts. If the impacts can't be fully mitigated, then you're into a request for review stage. And there is a possibility that through that you can identify sufficient mitigation to not require an authorization. But in the event you can't fully mitigate all of the effects, then you're moving into a Fisheries Act authorization. So I think we've got another poll question here, Leah, if you want to pull that up. So just again, more of an interest sake, the poll on the types of projects that you get involved with that have works in or near water. And just again, the different types of projects will certainly result in a different approach on what regulatory mechanism is available to you. Just give it another couple seconds here. So again, a little bit of a mix, a lot of linear development and a lot of major projects that involve large footprints with a few folks involved with intakes, stream diversions, and bank stabilization. And obviously, these aren't all the projects that someone could be involved with, but again, I think there are some different regulatory mechanisms depending on the type of project that you might be involved with. So let's step through the basic process. So right now, there is some information on the DFO website to give guidance when you do not need to contact DFO and where the Fisheries Act doesn't apply. And right now, it really is limited to a very small group of activities and a small group of types of water bodies that don't need to be considered. There's information on implementing measures to protect fish and fish habitat associated with clear span bridges, bridge maintenance, and essentially on-land activities. And really, when you work through the details on the website, most of these measures to protect fish and fish habitat are essentially complete avoidance measures. So it's avoiding causing any sort of disruption within channel or within habitat. So this area of the website and the guidance and information provided here really does apply to projects that are working near water, but really doesn't apply to projects that are working in water. The exemption of water bodies, again, it does focus on industrial and private water bodies, but there is a caveat to that in that they can't be connected to any fish-bearing waters or fish habitat at any point in any given year. So again, it does, even if you've got a water body that might be connected intermittently, if it does connect to a downstream fish habitat, it may be considered under the Fisheries Act. And when we look at the measures to avoid impacts to fish and fish habitat, again, they're really designed to have a high level of assurance that you will prevent the death of fish and had on fish habitat. The one area is working within designated timing windows. And again, there's maybe a bit of grayness in the interpretation of that, in that it suggests that working in the timing windows is allowed, but as you work through everything else in the measures, it really defines and specifies complete avoidance of any footprint or habitat disturbance. And the one area, particularly associated with road crossings and clear span bridges, is that activity is allowed, and following through the measures to protect fish and fish habitat, it talks about maintaining riparian vegetation and minimizing disturbance, and it says avoiding tree removal. So depending on the location of that bridge, it may be difficult to actually meet all of the criteria that are outlined. So if you look at your project and it doesn't fit in those that initial category, that can be screened out where you don't need to contact DFO. The next step is where there is some work that has the potential to interact with fish and fish habitat, but you can effectively mitigate those impacts so that there isn't a residual effect. And this is where the codes of practice come into play. Right now, as I mentioned, there's only the two in place. And a key point here is that you do need to follow all of the mitigation measures outlined in the code of practice. Even if you can hit 90% of the measures identified, but you miss on one or two of them, that's still an indication that you should then move to a request for review, which doesn't mean that it necessarily requires an authorization, but it does indicate that it's a situation that isn't that warrants additional insight from DFO. I guess the one of the key factors here and a consideration is that with the codes of practice, it tends to indicate if you are in an area where there's a species at risk listed under SARA, that the code of practice wouldn't apply. And I'll talk about that a little bit more at the end of the presentation. So if you can't check the boxes on those first two steps, you're likely into the request for review stage, and this is where you will need some additional information, typically some site-specific information about where the works will happen, so that you can adequately identify the impacts to fish and fish habitat that can't be avoided. You can go through the mitigation measures that are proposed and specific to your project. You might be able to identify the mitigations that you couldn't meet if it was a code of practice, but potentially provide a determination if not meeting that mitigation will still result in a HAD. DFO will review the plans and identify the potential risks, and they have a couple of options in their toolbox available to them. They may issue a letter of advice, so they will review the project and feel that the impacts can be effectively mitigated, and issue the letter indicating if you do follow all of the mitigations outlined that you should be able to avoid a HAD. This is a non-regulatory tool. It is not an authorization, so the proponent is still responsible for avoiding a HAD and avoiding the death of fish. And so if things don't go according to plan and you believe you've got the potential or the imminent potential to cause a HAD, then there is a duty to notify and to report that is happening. So again, the letter of advice allows you to move forward without the authorization, but it is not an authorization. If in the review process, then DFO determines that they believe that a HAD can't be effectively mitigated and there's still some residual effects, then it moves to an application for authorization. And at this stage, you should have some very good and detailed information on the physical footprint and the details of the activity. You need to outline all of the avoidance and mitigation measures that applied, and this is the stage where you start evaluating the potential effects to the project and to the existing fish community and the productivity of the fish and the fish habitat affected to help identify the residual impacts after the mitigation measures have been applied. The DFO website, again, there's some good guidance documentation on there, and it very explicitly outlines the information that's required. One of the first steps in their review is to essentially determine if your application is complete. So if you're missing any of the information that is outlined, they will essentially reject the application as being incomplete and return it back to you. A lot of it's very basic information, but there are some things that are likely inconsistent and could be different from project to project. The level of consultation that's been completed around the project, the effects to fish and fish habitat is going to be something that could vary from project to project, where DFO guidance indicates for smaller, simple programs, you may still be able to use fairly simple metrics on habitat area, and as projects become larger and more complex, it's looking at more quantitative assessments of habitat suitability or population modeling or productivity modeling. At the time of your application, there is the requirement to develop and submit an offsetting plan, as well as some financial assurance and a letter of credit that's put up to cover the cost of the offsetting plan and the maintenance and monitoring. And again, often we see that this is an area where that is often seen as incomplete, where the letter of credit isn't submitted right at the time the application is provided, and that's a reason for DFO to deem the application incomplete. So a bit of a flow chart, and hopefully everyone can see this reasonably well. but again, starting right at the top of assessing if you can completely avoid impacts to fish habitat, and can follow those measures on DFO's website, and it's one of the projects listed there, then no authorizations required. You don't need to submit anything to DFO. You can just go ahead with your project. If you can't meet that fairly tight definition of works, then you look through around if you can effectively mitigate and avoid had and death of fish. First through if there's a standard or code of practice in place, and certainly if the code of practice is in place and you can meet all the conditions, then again an authorization is not required, and you can submit a notification to DFO. If you're uncertain, if there's a bit of gray area, again, the recommendation is that you should go forward and submit a request for review. And with that, for those site-specific conditions and activities, if DFO believes that the impacts can be effectively mitigated, you're likely to receive a letter of advice. But if you can't, and there are residual effects outstanding, they would reply that the project would need to go through an application for authorization. And I think just one quick point here is you may be dealing with a larger project and you know right up front that an application for authorization is going to be needed. It is DFO's strong preference that you still start with a request for review and get your biologist assigned at that step of the process, and then have the ability to interact and engage with DFO in the development and review of the project and development of the offsetting plan. They can and do have to accept an application for authorization without it going to a request for review, but it tends to be a bumpy road. And then once the application is received, again, they have to consider the factors that are now outlined in the Act in evaluating the project. And there still are options for DFO to either issue the authorization or refuse the authorization based on what's outlined. So I think we've got another poll question here quickly, Leah. So again, just with that overview, I guess just a sense of what regulatory tool applies most to your project. So I had 2 code of practice notifications in there, one for current, which is again just limited to the 2, or what you're hoping for as a future code of practice. So that might include culvert maintenance, beaver dam removal, working in the dry, even considering what might have been available under the old operational statements. Great. So I think again, I think that seems reasonable where most people are looking at submitting requests for reviews with the hopes of getting a letter of advice or moving forward to a Fisheries Act authorization, with still a good number looking at codes of practice for future activities that DFO hasn't quite gotten complete. So just quickly in terms, I'll quickly go to some of the details needed in an offsetting plan, which again is now a requirement at the time of application. And again, this is something that has changed over time. Pre-2012, you could often submit a fairly conceptual offsetting or compensation plan at the time of your application and work through the plan during the review process. In 2012, that changed to having to submit your detailed offsetting plan up front, and that requirement has maintained. Similar, again, there is guidance on DFO's website as to the details required within your offsetting plan. And I won't go through them entirely here, but again, a couple of key points are, a summary of your proponent-led Indigenous consultation, and I think there is again a very strong focus on having that information available and upfront. The other point to consider is at the time of your offsetting plan, you do need to develop a fairly detailed monitoring plan associated with it to assess the effectiveness and to be able to demonstrate equivalency has been achieved. Again, this has been a bit of a change and a moving target over time, where previously you could submit your application with a fairly conceptual monitoring plan and develop it and revise it over time, where now again they're asking for quite a bit of information up front. And the last bullet is being able to identify the adverse effects, and this is going to be something that's variable and a decision to be made on how exactly you're going to be modeling project impacts, as well as the gains achieved in your offsetting, and what we like to say, defining your currency. Is it going to be a habitat-based assessment? Is it going to be a productivity-based assessment? So that again, you can quantify the effects, quantify the gains achieved from offsetting, and develop that equivalency piece. Here's another. This is from DFO's website, or from their offsetting policy, and again, just a bit of a schematic to demonstrate how they're viewing and how you need to go about defining your offset. So again, starting with the project and the predicted effects, again, being able to directly identify any avoidance measures that have been implemented with the project. Add on top of that the mitigation measures that have been added to the project. And I'll say, you know, in the codes of practice, or even a request for review that ends at a letter of advice, the intent is that, you know, the no change line kind of ends here, that your measures to avoid and your measures to mitigate can result in no change to basically to fish productivity, or to long-term harmful alteration to the fish habitat. If you do identify those residual effects, then again, you need these measures to offset. And I think there is no reference to a ratio in situations where potentially a proponent has built offset. DFO's preference is the offsets be built early and even potentially before the impact happens. And if that is the case, if they're built early before the impact happens, and you can demonstrate that they are effectively working, then that measures to offset and to achieve equivalency can be at a 1-to-1 ratio. As you add in time lags, and as you add in uncertainty on whether your offset will be will meet all of the objectives that are outlined, that's when the ratios start to increase, and the greater the uncertainty and the greater the time lag, the greater the ratio, and it can potentially go well beyond 2-to-1. One last point here on monitoring. Again, this is something that really has been a focus of DFO, I think, in recent years, and is an increasing requirement on projects to do monitoring of the offsetting measures. Again, in the past, it was the if you build it, they will come model, I believe, and if you simply just did some monitoring to demonstrate you had built what you had said you would, then that was often deemed a success, where current monitoring is certainly focused more on demonstrating that you've got the ecological function, and you're actually demonstrating equivalency based on the metrics that were used in your offsetting plan. Quick note here, I was chatting with DFO the other day that they are working on developing a more standardized monitoring framework, and are hoping to roll that out relatively soon. And this may actually apply to more smaller scale projects, or if you've got a code of practice or even a letter of advice. There may be some basic monitoring commitments associated with that are standardized across projects. So that's a work in progress, but potentially there could be something on that coming out as early as 2021. A couple final slides, just as again, not directly associated with your Fisheries Act approval or authorization, but in Alberta, again, something new for us to deal with is that also late in 2019, there was a lot of new area in the province that got mapped and listed for species that are listed under SARA and Schedule 1 under SARA. So both bull trout and Athabasca rainbow trout were added to SARA. And so there is now a much larger geography in Alberta that is mapped as potential habitat. So if your project happens to land in one of these areas that's currently mapped, it doesn't mean that it's necessarily critical habitat or key habitat for that species, but it does indicate that you'd likely need to go and do some site-specific evaluation and submit a request for review, even if you're dealing with the code of practice. And the final point is, again, there were a number of additional changes that were part of the Act that I think will be a critical piece moving forward, but again, there's still a lot of uncertainty. So the idea that you can amend, change, or cancel an existing authorization is a tool that apparently was never available to DFO, even though they did it on occasion, but it is now officially allowed. I think what's still a bit unknown is the extent and type of changes that can be made. So if you're making a substantive change to your project or the type of impacts, it may not be possible through this amendment process, or it may need to go through a more rigorous consultation process. The idea of designated projects is again something for the future. I don't really have any insight on the types of projects that they're looking for, but again, through this process with a designated project, you would go through a permitting process, so you get a permit instead of an authorization. And again, it defines some constraints around the types of projects and what can be done under those. And the last one is habitat banks. Habitat banks have been around for a bit. Although I'm not sure they're widely used. The clarification was that they would be proponent-led. And so if you do build a habitat bank, you can only use it for your own projects. You can't sell it. And I think the caveat here is that in developing a habitat bank, you need to build it, you need to monitor, you need to demonstrate it's effective before you can have a withdrawal. So final slide here, again, just looking at this time frame and of how a project review will happen. I think the big flag right now is the request for review stage. So there's no regulated time frame when you submit a project for a review, and because of maybe the fact that they haven't gotten the codes of practice in place, and there's a lot of projects that don't meet the avoidance criteria, that they have a huge backlog of projects on their desk. Currently, it was sitting at 3 months. So you submit a project to triage for review. It wasn't even getting opened for 3 months. I know DFO has reassigned and opened up a new triage group, at least in the short term, to try to clear that backlog. But as far as I know, there isn't a service standard on how long that initial review should take. Again, triage has the ability to issue a letter of advice, or if it's a bit more complex, they then assign it to a biologist for review. Again, that whole request for review, letter of advice, there are no regulated timelines around that. If you do need to go to the application for authorization, DFO's got 60 days to determine if it's complete, and there's a number of, if at any point they decide that they need more information, it's incomplete, they can send it back and the clock stops. And then the final one is once it is deemed complete, they've got 90 days to then issue your authorization. So with all of that, again, I still think, based on our experience, we're probably still looking at an 18 months to 24 month timeline if you need an authorization from when you kind of start with the collecting of baseline data all the way through to finally getting your authorization. So that is all for my presentation. There it is. Yep. I'm just gonna look over. Do we have any text questions yet, or people can start putting up their hands, I guess, to be unmuted and ask their question. So we got some people raising their hands, it looks like. Leah, I don't know how to.
Yeah, Stacy MacArthur, looks like your hand is raised. Do you want to go ahead?
Do you have to unmute all or just?
Yeah, everyone should be unmuted now, so you can just unmute if you do have a question.
Am I muted?
You're good. I can hear you now.
Okay, good. I was just wondering how they are bringing in the policy, which is not quite in place yet for water return, and what changes they're going to sort of be addressing when that policy comes into play.
For water return?
Yeah.
In what context?
For treated water return in the oil sands area. Yeah.
I don't know. So yeah, I don't know if that that would fall in one of the regulated project categories where you'd have a permit and permit conditions. So those are the types of projects I think that fit under that designated project category. But I don't have any insight on timing or what that would look like.
Okay, thanks.
Any other questions right now?
Amanda Mitchell, I see your hand is raised. Do you have a question?
I do. Sorry, I'm kind of co-parenting here at the moment too, so my apologies. In terms of like existing water crossings, like we work for pipeline, right? So a lot of time we're doing maintenance and activities such as like herbicide or brushing or whatever, and we have to cross our water crossings, and it's obviously become more tricky over time. Let's just put it that way, when we don't have existing permanent crossings in place. But how do you see this changing kind of like the operation side as opposed to the typical project things? Because I know we tend to be project focused.
Yeah, no, I think that's a good question, and I think the hope or the intent would be that it would eventually be covered under a code of practice and provide the constraints of what activities could proceed without requiring interaction with DFO. Interestingly enough, so like on the measures to protect fish and fish habitat and the avoidance measures, one of the things it talks about is avoiding fording of water courses. So in theory, I'm not sure. I think there's still a lot of gray zones associated with the information that we have available to us. That's certainly one of the gray zones, in that I'm pretty sure they don't want to be receiving reviews for single time forwards and things like that. So but right now it's it's not something that they've provided the clarity or definition on as to being an acceptable practice. But I think the maintenance of existing infrastructure, so as I mentioned, maintenance of culverts or I can see maintenance of existing linear crossings could be something that will hopefully come forward in a code of practice. But again, there's a lot of reluctance from DFO to identify what codes are coming and when they'll be available. I'm not sure if that was helpful, but
it was fairly helpful, as helpful as possible given the current situation. So I appreciate the insight. Thanks.
Okay. Who's next on the hands up? We had John Gurrow. John, are you able to unmute?
There we go. There we go.
There we are.
Sorry about that.
That's okay.
Thanks for the review, Kasey. Couple of things. When you talked about the 18 to 24 months for an authorization, I'm assuming that doesn't account for the Indigenous consultation, because as we know, that can take a considerable amount of time. And it's a new wrinkle in terms of seeking authorization for where it is required. So I imagine that alone could add a couple of years. I guess we have no, well, there is no precedent on that yet, I guess.
Yeah, so I guess the one point with that, and maybe where DFO is hoping, or the federal government is hoping, is that the consultation process maybe begins very early at the project planning stage. So it may be possible to at least demonstrate sufficient consultation at the time of your application if it's happening concurrently. So it is a wild card. There is no doubt, John, in terms of how long it takes. And I think as it has always happened, so DFO does have some requirements for the consideration of consultation, the consideration of Indigenous knowledge now, as well as the consideration of cumulative effects. And I think the more a proponent can do to satisfy those requirements is, I think, will continue to be seen as an ability to speed up the process from DFO's perspective. But what we have seen is that, that 90-day period to issue the authorization, is that DFO tends to spend most of that period in seeking additional and final consultation for their own sake. And again, if there's been a lot done already by the proponent, that period may go quicker. But we've certainly seen that that's one of the reasons where they stop the clock on that 90-day timeline, is if they've been asked or if there's additional consultation needed. So that is one of the risks of that 90-day time frame, and that could extend the whole process.
Okay, thank you. Sorry, just one other quick one. In the boreal, a lot of areas in the boreal where not a lot of topographic relief, we do get watercourse channels in broad floodplains that are basically wetland floodplains. In those wetland floodplains, have you seen any precedent in terms of how indirect effects have been considered if an activity is not within the watercourse channel but is within that floodplain? Any recent experience with that?
Nothing direct. I think, again, so the DFO's got they've got their full list of pathways of effects that kind of talk about different activities both in water as well as on land and next to water, and following through the pathways of effects to see if there's that potential linkage to fish habitat. So again, I think it's harder to demonstrate on both sides whether it actually does have an impact or it doesn't. There's a bit more uncertainty there, but I think there can be a lot of mitigation in place with those to demonstrate that you're doing everything you can to avoid the impact.
Okay, thank you.
Michelle McDonald, you had your hand up. And just give her a second to try to unmute. Oh, she may have lost connection. Just hold on for a second, Michelle. We'll try to get back to you. Tanya, Dale?
Hi, thank you. Are there any impacts to current projects that DFO would have given letters of advice on, or is this all effective as of August 28th, 2019, as when you are submitting your project?
So that's a great question. So a couple of points. Previously issued authorizations are carried forward, and so they cover the activity that's identified in the authorization. There was certainly a brief period with letters of advice that were issued just prior to the acts coming into force, where DFO was effectively considering those letters of advice as being reasonable, but the direct statement is that even with the letters of advice, again, they're not a regulatory mechanism. And so you still have the responsibility to determine if the mitigations outlined in the letter of advice that would have been focused on avoiding serious harm, if those still apply to avoiding a HAD. So you wouldn't necessarily be able to hold up your letter of advice that was received under the previous legislation to indicate that that you're satisfying the requirements of the current legislation. So it still is your responsibility to make sure that you're in compliance with the Act as it stands now. So the direction is to probably to have somebody take a look at that letter of advice, and really I think the timeline has likely passed in terms of the full leniency of DFO looking at it and considering it valid, and that you may need to at least connect with the biologist that issued the letter of advice to see if it's still applicable. But there is no grandfathering of letters of advice.
Thank you. I do have several projects that are ongoing from previous years.
Yeah,
that's helpful. Thank
yeah,
you.
it's tricky. It's a trickier one. Yeah, and I think there was a transition period for authorizations and projects that were in the process of getting an authorization, but that transition period is now passed, so I haven't really talked about that at all. I'm still seeing Michelle with a hand up. Are you still there, Michelle? Potentially not. Was there any, I think we've got a question on text. Are you anticipating any new changes within the DFO or the assessment process in light of the current economic challenges? I don't know. So again, the Act is still in place, and there certainly hasn't been any indication that you don't need to follow and abide by the prohibitions of the Act. Certainly, I think there's through discussions with different governments in terms of the need to monitor some things may be open. I haven't heard anything directly coming from the federal government or DFO with respect to that. But I think the Act itself is in place and hasn't been put on hold or anything like that. So there still is a requirement to meet the conditions of the Act. I think that's it. Is that all you see, Leah?
Yeah, that looks like it's all.
Okay. Well, thank you very much for everybody that attended today. I hope you found it useful. Certainly, if you've got any follow-up questions, you can reach out and contact myself or any of our biologists at Golder. But thanks again. Stay safe, and hopefully you're working effectively from home. Bye now.